May I please?
Yes. Call the list.
Item number 1.
Yes,
My
please.
lord, this is an appeal, my lord. Along with a miscase, there's a two miscase. One for the delay of 51 days, my lord, and another miscase was for staying of the operation of the impugned judgment and order, my lord.
Writ appeal.
Writ appeal, my lord. So the miscase is listed today for continuation of delay of 51 days, my lord.
Madam, we are condoning the delay. 51 days. She's for the respondents.
Are there for the respondents,
For the
GHDC,
District Council, Your Lordship.
private respondents.
Please, Lordship. So, I'll be filing the objection to the limitation application.
Which petition?
Yes, file the, I think, the application.
You are appearing for whom?
Concerning the delay. I'm appealing for the private respondent, my lord. Actually, yes.
53 days.
51 days, my lord.
What is the reason?
My lord, reason being I am changing the counsel, my lord, and after examining, my lord, certified copy was applied, then we file immediately, my lord, on 25, my lord.
Don't propose 53 days. Someday it will happen to you also to process your client's appeal or application. You will be delayed, and then if he objects to it, you will not like. So 53 days, don't object. 200, 300, we can understand.
But Lordship, there is another matter is there is no merit also because there is no affirmity with the order passed by the legislative bench because whatever any objection raised, they have never raised before. They have not even.
All right, you fight it out on merits.
My lord.
Fight it out on merits.
My lord.
The marginal delay of 52 days in preferring the appeal is condoned, comma, as sufficient cause has been shown for not preferring the appeal within the stipulated time. Next, hence, this application under Section 5 of the Limitation Act 1963, MC bracket WA 67 of 225 is allowed. We direct, next line, we direct the registry to register the appeal. Yes.
My lord.
The stay application?
My lord, yes, my lord. Stay application is there, my lord.
You want to move it today or some other day?
But I'll move it today, my lord.
You are ready?
Yes, Lordship, I'm ready, Lordship.
My lord, the impugned judgment and order was passed on 1/5/2025, my lord. Kindly, my lord, see the judgment, my lord, in the appeal. My entire thrust of argument, my lord, is on order.
No, where is the impugned judgment?
My lord, in the appeal, my lord.
Page 34, my lord.
Yes, my lord. Annexure 3, my lord. Annexure 3, my lord. Impugned order, my lord, at page 57 of my appeal, the operative portion, my lord. From, my lord, have.
It's 55 and 56 in our view.
Yes, my lord. 57, my lord, is the start from 57, para 4, my lord.
1st May.
My lord, the order dated, my lord.
Justice, thank you.
Yes, my lord. 1st May, my lord.
Yes.
Kindly come to page 57, my lord. The operative portion, my lord.
It is 56 here.
My lord,
Anyway,
yes, my lord. The para 4 and 5 is the last operative portion, my lord.
Mr. S.A. Sheikh.
Yes, my lord. Learned counsel for the respondent number 4, the appellant herein, has submitted that in fact election are not necessary as Sri Rizaul Karim appellant being the son of the late so-and-so Gaumbura by right can occupy the office. He further submits that the rule also do not provide the appointment should be by election, but the same can be also by selection. My lord, that is the main thrust, my lord. The rule which is adopted by the GHDC, Garo Hills Autonomous District Council, Tura, is, my lord, clause 162 stipulated for the appointment of Gaumpuras, my lord. clause 162 of Executive Instruction of Assam Land and Revenue Manual, my lord, which is adopted by the GHADC, it clearly says that.
So that the choice is made by the Deputy Commissioner.
No, my lord, it is actually in the Act, it is Deputy Commissioner, but it is in the GHADC, it is the Revenue Officer, my lord. But, my lord, the Deputy Commissioner is in state, my lord. Now, GHADC has a separate entity. GHADC, in case of GHADC, my lord, Garo Hills Autonomous District Council, it is, my lord, the Executive Officer, my lord. Chief Executive Officer and Secretary, my lord. Then Revenue Officer, it comes. Only the nomenclature, my lord. Change of nomenclature, my lord. The appointment of Gaumburas are in three conditions. Number one, views of the Mojeda. Number two, legal heirs of the previous Gaumbura. But here in the impugn order, my lord, the learned single judge has dehorsed the provision which is adopted by the GHADC under 162 and direct the respondent GHADC to conduct election of Magurmari village in the month of August, my lord. That is only my contention, my lord. Which rules does not provide, my lord. Even GHADC has no power to conduct election, my lord.
You are the legal heir of the deceased.
I am the legal heir, my lord.
Election has been conducted.
No, my lord. It's supposed to be conducted in the month of August as per the judgment, my lord.
Where is that Assam, that instruction, executive
My
instruction?
lord, I have, my lord. My lord, kindly have, my lord, this one.
Get another copy for my brother.
My lord, I have only
You should have
one.
made 2 photocopies of the relevant
My lord, yes,
instructions.
I would have, my lord. I bowed down, my lord. I have only the books, my lord.
Maybe Lordship. Before my learned friend started, there is even this rule. There is some observation has been. There is an order passed by this learned single bench regarding where my learned friend was relying. That regarding that also there is a discussion that has been there in that order has been there, Lordship. And this, moreover, this rule is not at all applicable because it's some line and revenue. And there is only one condition which I don't have to copy, but I remember that there's a choice. There's only one option.
This is a subdivision or?
My lord, this is
This is more for a deputy commissioner.
no, my lord. In Assam,
case of Sadar subdivision
no, my lord,
the
that
deputy
was
commissioner.
enacted by the Assam government. But in case of
or subdivisional officer in case of
yes, my lord.
outlying subdivisions.
My lord, actually, my lord, that was enacted by the Assam, and when adopted by the Garo Hills Autonomous District Council, the nomenclature of the officers will be changed, my lord. In several cases, my lord, judgments are also there where the GHADC has.
Bone Buddhas are appointed by the deputy commissioner. In case of vacancy, the deputy commissioner shall take into consideration the claims of the family,
Yes, sir. My lord.
the wishes of the villagers,
Wishes of the village.
and the views of the Mozada.
Mozadars, my lord. Mozadar here is, my lord, the appointed by the GHADC, my lord. And deputy commissioners herein, in our case, my lord, in case of GHADC, Garo Hills Autonomous District Council, will be the, my lord, Chief Executive Officer, my lord, Garo Hills Autonomous District Council. Because deputy commissioner is working under the government, my lord, under the government, and it's a separate entity.
So the wishes of the villagers can only come out of election.
My lord,
Yes.
which is why, my lord, we are on the second, my lord, the family member of the Gaungura, my lord. Now there is a report, my lord. After the before the disposal of this writ petition, there was a second round of inquiry. In that inquiry, which is not brought before the writ court, my lord, which needs to examine, my lord. Majority of the villagers are in support of the appellant, which GHADC has submitted. The inquiry officer had submitted before the GHADC respondents, my lord. At this stage, my lord, my only contention is, my lord, the impugned judgment and order may be stay, my lord. For
Then no election will be held.
no election may be held, and let the hearing, my lord, because counsel for
Lordship,
the GHADC.
my humble submission, Lordship, I have the strong objection regarding to the staying of the operation of the order passed by the learned single bench, because it's very clear that this is in the case of headman. There is a headman and Gangura. The headman is a Nokma. In the Nokma, there is an hereditary where without election that they can be appointed. Here, the rule is very clear. I will place because I have not given an opportunity. Also, I have not given a proper the book also, which I could not assist in a better way since they have not given the copy to me. Was for my understanding, even that rule which my learned friend is citing, even there is a discussion in other order. I'll be placing before this honorable court, or not today because I don't have that copy.
Who is
Because-
Mojadar?
My lord, Mozadar is appointed by the GHADC, an officer, my lord, who can have the to look after the village affairs, my lord,
He is appointed
by autonomous district council, my lord, Garo Hills Autonomous District Council, to collect the tax revenue from the villages, my lord, from land revenues, my lord. The patta holders, they used to some tax, and they used to collect, my lord, Mozadars.
My lord, may lordship. Even this rule is not applicable in the GHADC because it's a 60 area.
very much applicable.
Even if it is applicable also, your lordship, there is another judgment I'll be placing, your lordship. I'm given a chance. I will give a better assistance to this court because now I don't have the books also, even this one also. I'll be filing an objection to this regarding this stay because they have never raised this issue before the learned single bench. They have not even filed an affidavit.
This has to be filled up in August. The instruction clearly says the appointment is with the deputy commissioner, which in this case should be the
Chief Executive Officer, my lord,
of the council.
of the council, my lord.
All right. There are three factors he has to take into account. Claim of the family of the late Gaunbura, then wishes of the villagers, which can come out of election, and
Yes.
views of the Maujadar. He will allocate marks for each factor and make a selection.
But there is the Mojadar has conducted an inquiry. The Mojadar has not given any report in favor of the appellant, your lordship.
It's not question of report. Suppose the Maujadar says X and not Y or Z, then X will get 25 out of 25 and the others will get 0. And say, for example, wishes of the villagers in the election, say he is the winner, he will get 50 out of 50.
Here,
And claim of the family of the late Gaunbura
yes.
will be assessed.
Therefore,
50, 25, 25. Finished.
therefore, now the election has not been held, your lordship.
Let it be held. We are not holding it up. But just we do not want to stay the election to hear the appeal. Then there will be no Gaunbura for an indefinite period of time.
Yes, Lordship. That what we are saying that let there be an election.
Yes.
Yes.
My lord, as per the rules, my lord, as per the report, another inquiry report, my lord, the GHADC, the Council for the Respondents, my lord, GHADC, also has failed to bring on record before the writ court, my lord. In that said report, my lord, the detailed inquiry was conducted and the villagers had participated, and majority of the villagers are in favor of the appellant, my lord. Which is why, my lord, there is no question of election, my lord.
He has not even filed an affidavit.
No.
Reported
My-
learned fingerprints.
My lord, we rely on the because the council has filed an affidavit, and we are on the statutory provision. We argued on the statutory provision under 160 clause 162, my lord, on two counts, my lord.
The appellant cannot make a plea which is not within the writ petition. This is
I'm
beyond
not-
the scope of the writ
Please
petition.
take down. As the point involved is very short, we propose to dispose of this appeal by treating it on the day's list and dispensing with all formalities. Paragraph. The subject matter of dispute in this appeal relates to the appointment of a Gaon Buddha on the death of the Gaon Buddha. No, on the death of the person who occupied this office. Paragraph. There is no dispute that the executive instructions under the Assam Land and Revenue Regulations 1886 are applicable in this appointment procedure. Paragraph. Instruction 162 is relevant, which is set out here under page 182 of this book. Paragraph. The only change in the application of this instruction in the state of Meghalaya is that in case of deputy commissioner, the appointing authority is the chief executive officer or
Chief Executive Member, my lord.
chief executive member
GHADC, Tura.
of the.
Garo Hills Autonomous District Council, Tura.
All right, you got it?
Yes.
Paragraph. Now, under the above instruction, this officer has to take into account the suitability of the legal heirs and representatives of the deceased Gaon Bura. B, the will of the villagers. And C, the opinion of the Mawzadar. Paragraph. We are told that the chief executive member has called for an election procedure to select or appoint the Gaon Bura, where the villagers would vote in favor of candidates who have filed nomination. Full stop. We are not aware of the procedure the chief executive officer proposes to follow after the results of the election are known. Paragraph. In our view, holding an election is in consonance with instruction B of instruction 162B, where the officer is required to take into consideration the wishes of the villagers. However, he is also to take into account the quotation claims of the family of the late Gaon Bura, unquote, and quotation the view of the Mawzadar. Paragraph. In those the detailed procedure is not prescribed in the instruction. Paragraph. We are of the view that the chief executive officer of the said council may proceed with the appointment process by holding the election, full stop. He is also directed he is also directed to treat the appointment procedure as a kind of selection test carrying 100 marks, where the will of the villagers reflected in the election could carry up to 60 marks. Should carry 60 marks. And the claim of the legal heirs and the views of the Mawzadar to comprise of 20 marks each. Paragraph. On that basis, the Chief Executive Officer may select and appoint the subject Gaun Bola. Within the time stipulated by, it's in the rules, August.
My lord,
August, yes.
yes, as
The
per
month of
the
August.
impugn, it's by August, my lord.
As per the order dated 01/5/2025.
By August 2025. This appeal and the miscellaneous application are disposed of accordingly.
I'll oblige.
Much less lordship.
Number 2.
The impugned judgment and order is modified to the above extent.
You please, my lords.
Yes,
These appeals, this appeal, my lords, at item number 2 was directed to be listed, my lords, along with another connected set of appeals which are listed tomorrow before my lords. I think they have come wrongly. However, my lords, since my friend is here, there is a marginal delay of 21 days, my lords. That's because of the fact that there was a review filed before the learned single judge, which came to be disposed of, my lords. So I was praying if my lords were kindly pleased to condone the delay, my lords, and fix the matter next week for admission, my lords, if that would be convenient for my lords.
this is the new appeal.
My lords, this is the new
20 days delay.
21 days delay.
21 days.
Because of filing of the
We are
review.
condoning the delay, Mr. Mandu.
Mullets.
The marginal delay of 28 days.
21, my lords.
21 days in preparing the appeal is condoned, as sufficient cause is shown by the appellant for not preparing the appeal within time. Paragraph. Hence, the section 5, the application under section 5 of the Limitation Act 1963 is allowed. Next, we direct the registry to register the appeal. And to list it with the connected appeals.
My lords, connected appeals are coming tomorrow. I was praying if that can be all be taken up together next week, my lords. I'll make a similar prayer tomorrow. Your lordships can fix a date in this matter. I'll make a similar prayer for fixing all the matters for admission sometime next week, my lords, as may be convenient to my lords.
If your lordships finds it convenient, my lords, all matters can be fixed on 7th.
Oh, fifth, sixth, seventh, my lords, any date is convenient, subject to my lord's convenience, of course.
This appeal, along with the connected appeals, which are scheduled to be listed tomorrow, bracket 30th July, bracket closed. On 7th August.
7th August. Highly obliged.
Okay. Highly okay.
Highly obliged.
Number 3.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to seek an indulgence beg for an adjournment, Your Lordship, since the conducting counsel, he had to leave for the hospital, Your Lordship, because his sugar was too high. It was 5:35, Your Lordship.
This is a criminal matter.
Yes, Your Lordship, criminal appeal. My Lordship, I pray if this matter can come after 2 weeks, Your Lordship.
Mr. Mahanta,
Yes, Your Lordship.
where is he? Here or in
He
Guwahati?
left for Negrims, Your Lordship. His sugar was 5:35, that's why.
Lordship will recollect on the last date. I closed my arguments on fact. Order was passed, Lordship. I was supposed to give only a reply on law point.
Yes.
So I thought before.
No, let him finish. You take notes because he'll be only citing cases. And thereafter, when Mr. Mahanta is all right, he will come and make his arguments.
Lordship, yes, Lordship. In the court, please.
Suddenly his sugar went up.
Yes, Your Lordship. Your Lordship, if it does not create any inconvenience for this court.
Sorry?
If it does not create any inconvenience for this court, let this matter come up after 2 weeks, Your Lordship.
No, that is all right. Learned Additional Advocate General has finished his arguments.
Yes, Your Lordship.
He has some only cases to cite. So let him finish it.
Okay, Your
What
Lordship.
is your problem? You take note.
Yes, Your Lordship. I'll do that. Obliged, Your Lordship.
Didi. Lordship, I just prepared a brief note. So I thought if I just cite the judgment, Your Lordship, then I had to relate it back. So to make convenient for the court also, Your Lordship.
Yes, most helpful.
Lordship, yes. So it took a lot of time because I had to correlate. So, Lordship, hurriedly, first law point, Lordship, I'll rely is on res gestatis. That is at page 2. 2011 7 SSC. We shall now deal with the section 6 of the Act, which reads as under relevancy of fact forming parts of the same transaction. Facts which, though not in issue, are so connected with the facts in issue as to form part of the same transactions are relevant, whether they occurred at the same time and place or at different times and place. And Honorable Supreme Court has relied on para 35 of Black Law Dictionary. It says the events at issue or events contemporaries with them. In evidence law, words and statements about the res gestatis are usually admissible under
Yes.
Sorry, Lordship. So it's an exception to hearsay argument, and 36 is a relevant part, Your Lordship. On Supreme page para 36, the said evidence thus becomes relevant and admissible as res gestatis under section 6 of the Act. So far res gestatis is concerned, Your Lordship, I have already given an explanation how I've said in the previous paragraph, PW 1, 2 and 5. So the evidence come within and the law is applicable on that. And so, Your Lordship, the second judgment I'm relying is at the 4th page, Your Lordship. Lordship, if I may just start from the top, Your Lordship. Exhibiting confessional statement is not mandatorily required under Section 80 of the evidence and the contents of confessional statement if not challenged by the accused by resorting to Section 315 and also 463 of the CRPC. The same becomes not only admissible but also duly proved under law. The Lordship, exactly this issue was raised before Honorable Supreme Court in 1981. And para 5, the sub-para, Lordship, I just quoted this. This is Madi Ganga versus State of Orissa. An argument was raised by Mr. Jain, submission that learned magistrate should have been examined as a witness. Section 80 of the Evidence Act makes examination of the magistrate unnecessary. It authorizes the court to presume that a document is genuine and that any statement as to circumstances under which it was taken are true and that such confession was duly taken in accordance with law. Shri Jain submitted that if the magistrate has been examined as the witness, the accused might have been in a position to show by cross-examination that the confession recorded by the magistrate was not voluntary. The magistrate was appended a certificate that he was satisfied that the confession was voluntary. No circumstances have been brought out in the evidence justifying the calling of the magistrate as witness. This is very important, Your Lordship. We do not think that the circumstances of the case justify any comments on the alleged failure of the prosecution to examine the magistrate as witness. Though there are two parts, Your Lordship, though the magistrate is not mandatory, and in case they wanted to cross-check the position, Your Lordship, that is how I argued, Your Lordship, they could have brought in, the accused could have been a witness in the 315. And there is no evidence on record to show how they have been deprived. So this judgment squarely covers, Your Lordship, that exhibiting the magistrate's presence is not mandatory.
Yes.
Lordship, the third judgment is at this next page, Your Lordship, from the bottom. Lordship, I had argued on the exculpatory and the inculpatory part. So the detailed discussion is, Lordship, is on the previous paragraph. I'll just come to the relevant Supreme Court judgment on this, Lordship.
Yes.
It has been held by Honorable Supreme Court in a judgment of so-and-so that court can, while considering confessional statement, accept the whole confessional statement, though the same may have inculpatory statement as well as exculpatory statement. This is para 6 of the same judgment, Your Lordship. Without wasting court's time, Your Lordship, just come to the operative part is the underlined part, Your Lordship. If I may just read the underlined part. This court has held that it is permissible to believe one part of the confessional statement and to disbelieve another, and that it is enough if the whole of the confession is tendered in evidence so that it may be open to the court to reject the exculpatory part and to take inculpatory part into consideration if there is other evidence to prove its correctness. So our case is clearly clear, Lordship, inculpatory and exculpatory. I have argued at length on facts. So it is permissible to take and this was decided way back in 1976, Lordship. And so the moment we address the issues of inculpatory and exculpatory, the next judgment, Lordship, I am relying in the last paragraph, same page, Lordship. Further, insofar as admissibility of confession statement and admissible statement is concerned, the law is as follows. Lordship, this judgment 2005-11 SCC 2600 is a very, very elaborate judgment, Lordship, runs into some 197 pages, but the para 27, Lordship, it's mutatis mutandis applicable to my case. And para 7, if I may just allow very short paragraph, Lordship. Inculpatory, I am relying on the confessional statement, exculpatory on the admission. Para 27 says, we start with confession. Under general law of land, as reflected in Evidence Act, no confession made to the police officer can be proved against an accused. The next paragraph, next line is important. Confession, which is a terminology used in criminal law, is a species of admission, as defined in section 17 of the Evidence Act. An admission is a statement, oral or documentary, which enables the court to draw an inference as to any fact in the issue of relevance. It is prior to say that every confession must be necessarily be an admission, but every admission does not necessarily amounting to confession. I made a distinction, Your Lordship, how confession will be governed by section 26 and how admission will be governed by section 70. Though, Lordship, I have categorically stated that though this judgment is very elaborate on a different context, the ratio of the judgment more particularly governing confessional statement and admission will be mutatis mutandis applicable to the innocent case as also. As I submitted, Lordship, this is a very elaborate judgment concerning a very different issue, but court had an occasion in para 27 to discuss a distinction of this. Next issue, Your Lordship, learned senior counsel had raised the issue that and it's an admitted fact, Your Lordship, that the confessional statement was recorded on oath.
Yes.
On oath. Lordship, our honorable own High Court, Your Lordship, this issue was argued at length, and the next judgment I relying, Your Lordship, the relevant paragraph is at paragraph 14. In Criminal Appeal 21 of 2019, parties number so and so, this issue was argued. And this honorable court, Your Lordship, this division bench had held, in the context of section 164 of the code, the mandate therein is to scrupulously follow the safeguards to ensure that the confession is voluntarily made. The safeguard indicated in the provisions are substantive contents of law laid down therein, and the exemptions of the maker of the confessional statement from being administered oath is merely procedural.
Yes.
So the issue was administering oath. The court held that it was merely procedural so that any part of the confession, if subsequently discovered to be false, leaves him immune to prosecution for perjury. If the salutary safeguards, Lordship, allow me to just pause for a minute. This finding of our own High Court Division Bench, Lordship, with all humility at my command, it's a landmark observation because this has expanded the frontiers of criminal jurisprudence. That what is the purpose of oath and why not? I haven't come across specifically this part. Even Supreme Court has not entered into it. High Court has clarified that. So if the salutary safeguards are enumerated in section 64 of the code are followed while recording a confessional statement, mere fact, this is important, Lordship, mere fact that oath may have been administered to the maker of the statement would not vitiate the same or rob the confession of its evidentiary value. However, the immunity against perjury would still be in place despite the confessional statement being obtained under oath. And last, Your Lordship, as such, the issue on oath under 164, so far as confessional statements are concerned, it's no longer in res integra. It's a settle. And Lordship, so these are the few judgments that I argued at length, Your Lordship, whether it's, so I've just given the copy to
Say a dying declaration.
32, Evidence
It
Act.
is made in a hospital usually, in the presence of some person, often in the presence of police officers.
Lordship.
Or any other confessional statement of, which are in the nature of res geste or of the victim, not of the victim, of the accused, while or just after committing the offence, making a statement which somebody has heard. So it did not be on oath?
No. No, Lordship. So the only thing that the link has to be maintained. The link has to be maintained that the proximity of statement made, there has to be continuation of the...
So confession may not be only under 164.
Lordship. Lordship, there is another term called extrajudicial confession.
Yes.
It's a very weak piece of evidence. For that confession, you don't need a magistrate or a police. You could say it to anybody. So that anybody could be anybody,
So
and then
the
he has
Supreme
to...
Court says it is a species of admission.
Absolutely, Lordship.
Say, right after committing a murder,
No, sure.
say if somebody slips into a room where his friend is there or some compatriot is hiding and says that, yes, I have accomplished the act which I had contemplated, I have finished him.
No, sure, I'm grateful.
And say a potential witness hears it, sees him making that statement. So when he gives evidence of that statement, so that statement becomes a confession, which
Lordship, and it legally known as extrajudicial confession. The term is extrajudicial
yes.
because it was not given in police custody or it was not given in court custody.
But he was heard making an admission or confession.
And that statement, Lordship, interestingly, Supreme Court has held it's a very weak piece of evidence. Very weak. It needs very, very more corroboration. Small example, Lordship, if I can give. Just recently, we were keeping track of the news, what happened in the death sentence confirmation in Bombay matters, 2007.
Yes, yes.
In that, this was two very, very final, this issue was involved. A session judge convicted 5 people to death, the rest was for life. One of the most important evidence was extrajudicial confession. And the division bench was asked to confirm the death. It has never happened in Lordship. It's a landmark case for, I think, for almost most of the lawyers. What happened was instead of confirming that, it acquitted. So, and it was basically extrajudicial confession. Of course, there were other things, but this was one of the prime issue involved. So Lordship, so far confession is concerned, we are protected at 26. And last, Lordship, my submission here, Lordship, is that the exculpatory part, which 106 was required to prove, Lordship, that has been also proved that the murder was committed. And so most of the facts are covered by these 4 important judgments, Your Lordship, and there's nothing much. I've given the copy.
I've received, Your Lordship.
All right. So when
After 2 weeks, Your Lordship.
ask Mr. Khan, when will be convenient?
It's up to them, Your Lordship, whenever they
After
are
2 weeks, Your
convenient.
Lordship.
So Mr. Khan, Learned Additional Advocate General, concludes his arguments on behalf of the prosecution.
My only submission, Your Lordship, if they also can give, I have given a written reply, anything on law point, maybe a small date, short date can be fixed, they can always ask for time, Lordship.
We'll prepare, Your Lordship.
When would Mr. Mohanta be
After
ready?
2 weeks, Your Lordship will be in a better position to appear.
Considering the personal difficulty on account of health of learned counsel for the respondent accused, no, for the appellant accused, list is appealed for further hearing. On behalf of the accused on 12th August.
Okay, Your Lordship.
Number 4.
Oblige, Your Lordship.
Oblige.
Thanks.
Yes.
May it please, Your Lordship. This matter had come up yesterday, Miller. And
Rent control. Rent control.
yes, my lord, rent control. Miller, there is a delay of 287 days on the, and we have
Yes.
prayed for convention of delay. as your lordship was querying on the merits of the case, my lord.
No, but he is opposing the Section 5 application. So you place it shortly. Let us see what he has to say.
Sorry, my lord.
You place your application, then let us see what he has to
My
say.
lord. My lord, our application is only on two grounds, my lord. That is, firstly, my lord, on the illness in the, my lord, in the, on the advocate's family, my lord. And then secondly, my lord, on the illness of the person himself, the appellant himself. My lord. That is the case, my lord.
Where have you pleaded it, Mr. Shafrut?
My lord. Well, para 3 of the application for condemnation. Yes. If your lordships come to para 3 of the application, my lord. In that application for condemnation of delay, my lord,
Paragraph 3.
paragraph 3.
How have you dealt with it?
Lordship,
How have you dealt with paragraph 3?
Lordship, my submission is that Lordship,
How have you dealt with it in your opposition? How have you dealt with paragraph 3?
Lordship, huh? Oh, objection. Oh, Lordship, my response is that Lordship, it is that Lordship, they are saying that the advocates, they could not, advocates of the applicant, they could not file the appeal on within the limitation period. But Lordship, those advocates, they can file other petition and they can appear in other cases also, Lordship. As I have stated in my counter affidavit at para number 5, Lordship, I have stated.
Give the counter affidavit.
What they have pointed out is.
No, Mr. Chauku, please kindly take this.
Para number 6, Lordship. They have stated, Lordship, I may allow to read, Lordship.
Paragraph?
Paragraph 5, Lordship, of my counter. Lordship,
You have allowed this affidavit to be filed.
Lordship,
You have allowed this affidavit to be filed yourself as a lawyer.
Lordship,
Senior advocate, he says his wife has heart ailment,
Lordship,
open surgery, bypass surgery had to be performed,
Lordship.
and your client will come and file an affidavit denying that,
Lordship, the
and you
senior
have permitted it to be filed.
Lordship, I may allow to submit. Lordship, the senior advocate has also appeared in these matters. Not
All right,
on-
we will put your client in the box, ask him to come. They will cross-examine him. Let him prove his statement. We will put him in the box here.
Lordship,
Ask him to come. How he knows all these things.
Lordship,
How he has verified it as true to his knowledge
Lordship,
and derived from information. How he has acquired this knowledge,
Lordship,
which means the alleged falsehood of the statements being made on behalf of a senior advocate.
Lordship,
What is all this going
Lordship,
on?
as per the court order, Lordship, I may be allowed to bring on record those court orders, Lordship.
Why?
To be to on record, Lordship, that the senior counsel and
Senior counsel will write bypass surgery will delay in a fortnight like this. Otherwise, this nonsense will. Your clients will come and question. What do you say?
besides, Lordship, I may allow to submit.
You want to go to the Supreme Court, you go to the Supreme Court. We are very firm on this. We will not allow the tradition of this court to be to fall.
Lordship, one more submission, Lordship. Apart from this, Lordship, the appellant, Lordship, here did not explain why the appeal was not filed within limitation period of 30 days, Lordship. Also,
Very good. You fight out the matter on merits, or what is the effect of not depositing the rent and all that. But this kind of thing of medical ground illness, your client will come and in an affidavit challenge all this, will not be, at least I will not tolerate this. Please take note.
Lordship, I may be allowed to place one citation, Lordship.
You are a member of the profession. Don't denigrate your own profession. What you are doing, you are challenging the truth of a statement made by your senior friend. What is all this going on? It is never done. And all for a client. He will come and go. He will pay you today, he will not pay you tomorrow. But then you are bringing down the whole institution in that way. Please take down. Well, what is the delay, Mr. Chakraborty?
287 days.
Yes. There is a delay of 287 days in preferring the appeal. Full stop. The principal ground made out to explain this delay is on account of a learned senior advocate engaged for the appellant. No, the principal ground made out, please scratch it out. The principal ground made out in this application under Section 5 of the Limitation Act is that the wife of the senior advocate engaged by the appellant to conduct the appeal had to undergo a major open heart surgery. And for that reason, drafting and filing of the appeal was delayed. Paragraph. It is not anybody's case that the appellant was responsible for the delay. Paragraph. The Supreme Court has told us over the years by various decisions that a litigant does not benefit by delaying an appeal. Full stop. In fact, he runs a serious risk by doing so. Secondly, a litigant should not be made to suffer any consequence for which he was not responsible, but the responsibility he was not responsible, and the cause of the delay was his learned lawyer. Paragraph. In this case, it was not casual delay. No, it was not delay caused by a casual attitude on the part of the learned lawyer. Full stop. It has been stated on oath that a member of his family was suffering from a very serious illness which he had to attend to. Full stop. No, serious illness which he had to attend to, and for which the appeal could not be filed within time. Paragraph. We accept the explanation. Full stop. And condone the delay. We allow this application under Section 5 of the Limitation Act. We direct the registry to register the appeal. You file paper books? Appeal, we formally admit the appeal as all the respondents are represented.
I am for the state, but though state is not a contesting party.
Correct. As the respondents are represented, we dispense with all formalities and expedite the appeal. Advocate on record for the appellant will file an informal paperwork, usual thing, by August 22nd, list the appeal for hearing on 1st September.
Highly obliged.
Obliged, Your Honor.
You are still not very senior in the profession. Never, never, never. If it's a ground of a learned advocate,
Yes.
at least you don't stand up and challenge it. Whatever your client might say. Because you're a member of the bar, you have to stay in the bar with the bar.
Yes.
All right? Don't do it.
Apologies.
Well,